Hello, everybody, and welcome to the July Landlord Law Training Webinar. And I'm thrilled to have Dean Underwood with us today. And Dean is an expert on HMO and rent repayment orders. So as there's been quite a lot of development in the law relating to rent repayment orders, I thought, because he did a webinar for us last year, but I thought it was time we brought him back again to talk us through some of the legal developments. So Dean is a barrister. What's your chambers? I've forgotten momentarily, Dean.
It's Cornerstone Barristers in Gray's Inn.
Cornerstone Barristers, of course. So Dean is a housing barrister specialising in HMO work at Cornerstone. So welcome, Dean.
Tessa, thank you very much. It's always a pleasure to do one of your webinars, and a real pleasure to be invited back. So thank you very much for that, and indeed for the flattering introduction.
Okay, right. Well, I'll leave it to you. If anybody's got any questions, put them in the chat box, and I'll put them to Dean at a suitable moment.
That's great. Thank you, Tessa. Well, as Tessa rightly said, today we're going to be talking about rent repayment orders, and in particular, we're going to be looking at some of the key developments that have taken place recently, in the last 12 months in particular, in respect of rent repayment orders under, as many of you will know, I'm sure, under Part 2 of the Housing and Planning Act 2016. For those of you who don't know, Part 2 of the 2016 Act is the part of the statute that enacts rent repayment orders and gives details about how they are to be made and calculated. So our focus today is going to be on 5 or 6 cases in particular. The last year has been a particularly busy year, in particular in the upper tribunal, who've had to contend with a series of issues, many of them important in principle, about the application of the statutory regime under Part 2 and how to calculate rent repayment orders properly. So to help you today, I have included throughout the slides links to the decisions online and also links to the various statutory provisions to which we'll be referring. So either at your leisure or indeed as we're going along today, you can simply click on the link and it will take you to the relevant page online.
I better load it up then. I haven't actually loaded up the handout, but I will do so now. But the handout will be available with the recording of the webinar. Perhaps you could briefly tell people what a rent repayment order is. I'm sure everybody knows, but just in case.
Yeah, of course. So under Part 2 of the 2016 Act, the First Tier Tribunal has power to make a rent repayment order where the landlord has committed one or more of several housing offences, and materially for today's purposes, they include licensing offences under, for example, Section 72(1) or Section 95(1) of the 2004 Act. Those offences being where a person having control of or managing a property, which is either a Part 3 house or a house in multiple occupation under Part 2, does not have a licence to let that property from the local housing authority. It includes various other offences, including offences of harassment under the Protection from Eviction Act 1977. I've referred to that later in the slides as PEA 1977 for those who might question that abbreviation. So that's the Protection from Eviction Act 1977. So the local authority, or indeed the landlord's tenants, can apply to the First Tier Tribunal for a rent repayment order. And unless the landlord has already been either convicted or penalised for one of those relevant offences, the First Tier Tribunal will consider afresh, consider from the outset whether the offence has been committed to the criminal standard of proof. And if it's satisfied of that, then provided a series of procedural requirements have been complied with, it can go on to make a rent repayment order. And the way in which it calculates it, again, depends to an extent on whether the landlord has previously been convicted or penalised for the offence. If they haven't, then under Section 44, for example, the First Tier Tribunal has a discretion as to the amount of the penalty, as for the amount of the order rather, The starting point, generally speaking, is the maximum is the rent paid during that period. That is the starting point on a statutory analysis. But as we will see from cases that have been decided just this year, that can be reduced by a significant sum to take into account procedures that the first tier tribunal has to consider when it calculates the amount. And that includes the tenant's conduct and indeed the landlord's conduct. The position is somewhat different if the landlord has already been convicted or penalised for one of the relevant offences. In that case, the first tier tribunal doesn't really have a discretion, save in exceptional circumstances. And so it is required in those circumstances to make a rent repayment order for the maximum amount that is possible under Section 45, for example, but disregarding issues such as tenants and landlords' conduct. So in that case, the first tier tribunal's hands are tied much more closely by statute. And generally speaking, save in exceptional circumstances, there is an expectation that they will make an order in the maximum amount.
So the moral of the story is don't have a
Don't
allow you
do
don't
anything.
allow you to be prosecuted, because the maximum amount is a year's rent, isn't it? Which is a massive amount of rent to have to pay back.
It is, and the scope for reductions from that amount, as we will see in due course in these cases, has been significantly reduced. So it is a significant amount. It has been described by the deputy president, I think, of the upper tribunal as a draconian measure. And to an extent, that's right, because of course, rent repayment orders can be made in addition to either, for example, a fine imposed by the magistrates court or a penalty imposed by the local housing authority under Section 249A, financial penalty.
So you really, really don't want this to happen to you.
So the first of our cases, Verdamile and Stewart, and I hope I've pronounced that correctly. This was a case in which the upper tribunal had to consider the extent to which the first tier tribunal was entitled to deduct certain expenditure on the landlord's part from the amount of a rent repayment order. So in this case, the landlord had failed to license what was in effect a flat in multiple occupation, which required a license, and had therefore committed an offence under Section 72 of the Housing Act 2004. That is, being a person managing or having control of a house in multiple occupation which requires a license and doesn't have one. As a result of that, of course, that being one of the relevant offences for which the first tier tribunal can make a rent repayment order, the tenant applied for an order for the 12-month period of the offence under, as we know, Part 2 of the 2016 Act. The rent for that period, and this comes back to the point that Tessa was making about this being a really serious order, the rent for that period was approximately £28,600. So it would have been a significant, and was a significant hammer blow to the landlord. So the landlord submitted, relying on previous authority, Parker and Waller, which I've given a link to there, that the first tier tribunal should deduct amounts that he'd spent on the flat in the relevant period, the relevant 12-month period. And that included amounts, for example, relating to the maintenance and repair of the property. The first tier tribunal accepted that submission, applying Parker and Waller, and deducted £5,373.89 from the final amount. It then considered what sum would be a reasonable sum for the landlord to pay, and deducted a further 25% from the sum of the order, because the landlord had fixed a number of problems at the flat. And we'll see in a moment that the upper tribunal took issue with that on a proper interpretation of the statute, and that has been reversed. So the landlord appealed against the rent repayment order, which was in the amount of £17,420. The landlord argued that the first tier tribunal should really have deducted further expenses and the amount of a financial penalty that had been applied by the local housing authority under Section 249A of the 2004 Act. Section 249A of the 2004 Act, of course, is the statutory mechanism under which local housing authorities have the power to impose a financial penalty. And in this case, that financial penalty was the not inconsiderable sum of £8,000. So it would have made a real difference to the amount payable.